Now, may I please request Sri Manoj Ahuja, Chief Secretary of Odisha, to felicitate the esteemed dignitaries on the dais. Shri Dharmender Pradhan, Shri Dharmender Pradhan, Honorable Minister of Education, Government of India. Honorable Sri Justice M.M. Sundares, Judge, Supreme Court of India. Honorable Sri Justice Sanjay Karol, Judge, Supreme Court of India. Honorable Sri Justice Ahsanuddin Amanullah, Judge, Supreme Court of India. Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Government of India. Honorable Sri Justice Harish Tandon, Chief Justice, Odisha High Court. Honorable Sri Justice Sangam Kumar Sahu, Judge, Odisha High Court. Honorable Justice Shri Krishna Ram Mahapatra, Judge, Odisha High Court. Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, Odisha High Court. Now, thank you so much, sir.
I request Chief Secretary to take the chair.
Now, I request Shri Manoj Ahuja, Chief Secretary of Odisha, to please take over the chair. Thank you so much, sir. Now I request Shri Pitambar Acharya, Learned Advocate General of Odisha, to preside over the valedictory section.
कार्ड कहाँ गया? इन जो सबका जो बुलाएंगे ना, जो एजेंडा Good evening. I now welcome Honorable Sri Justice K.R. Mahapatra, Judge, Odisha High Court, to give the welcome address.
Namaskar and a very good evening. Honorable Sri Dharmendra Pradhan ji, the Minister of Education, Government of India. Honorable Sri M.M. Sundaresh, Judge Supreme Court of India. Honorable Mr. Justice Sanjay Karol, Judge Supreme Court of India. Honorable Justice Asauddin Amanullah, Judge Supreme Court of India. Honorable Judges of the Supreme Court of India gracing the occasion. Honorable Sri Arjun Ram Meghwal, Minister of State, Ministry of Law and Justice, Government of India. Honorable Sri Harish Tandon, my Chief Justice, High Court of Odisha. Honorable Chief Justices and Honorable Judges of High Court who are present in this occasion. My esteemed sister and brother judges of the Odisha High Court and other different high courts of the country. Sri Tushar Mehta, Learned Solicitor General of India, Learned Additional Solicitor Generals, Sri Pitambar Acharya, Learned Advocate General, Odisha, Learned Advocate Generals of different states, Learned President and Office Bearers of the Odisha High Court Bar Association, respected senior advocates, mediators and academicians, officers of the Registry of the High Court of Odisha, learned judicial officers present, distinguished members of the bar, members of print and electronic media, ladies and gentlemen. It is my solemn privilege to welcome the honorable dignitaries, distinguished guests, and esteemed participants of the valedictory session of the Second National Mediation Conference 2025 that marks the conclusion of what has been a phenomenally enriching experience in the technical sessions. It was indeed a historic occasion in the chronicle of High Court of Odisha and legal landscape of the state of Odisha. Distinguished dignitaries from far and near gathered to contribute to this conference to make it such a grand success. Time flew through the indulging discussions and debates over so many sessions. Each session was enlightening and thought-provoking. As we reach the conclusion of the conference, I am honored to welcome you all to the valedictory session. The conference has been a vital step in deepening our collective understanding and role of mediation in justice delivery system. We feel particularly honored and gratified by the presence of Honorable Chief Justice of India, Honorable Judges of the Supreme Court of India, the Honorable Union Minister of Education, Honorable Minister of State, Minister of Law and Justice, Honorable Government of India. I extend my heartfelt welcome to all the dignitaries for their kind presence in this occasion. It is my proud privilege to welcome the Honorable Chief Justices and Honorable Judges of the High Courts whose contribution has made the technical sessions of the conference so meaningful. We are grateful for your participation, sirs. The contribution of senior mediators and mediators are also immensely enriched the discussions. I also extend a cordial, affectionate welcome to the learned Solicitor General of India, learned Advocate General of Odisha, and Mr. Venkat Ramani, the Attorney General of India. Distinguished members of the bar who are present with us on this occasion, the technical sessions on challenges, way forward, enhancement of mediation ecosystem, mediation in state litigation, commercial mediation, and institutional mediation witnessed some truly engaging discussions and discourses widening the horizon of mediation's landscape in our country. Thanks to the erudite inputs shared by the participating judges and legal professionals, I am sure this conference has given all of us to make a take back with us and reflect upon the covered those reflections into positive action. Once again, I extend my hearty welcome to all the dignitaries and esteemed participants and respected members of the audience to this valedictory session. Wish you a wonderful evening, ladies and gentlemen. Thank you. Namaskar.
Thank you, sir, for your insightful words. Now I request Shri Pitambar Acharya, Learned Advocate General, sir, to felicitate Shri Tushar Mehta, Solicitor General of India. Now I request Advocate General Sir of Odisha to kindly preside over the session.
Thank you and good evening to all of you. It's one of the most distinguished audiences I have ever seen in my life. On behalf of State of Odisha, the Department of Law, and on behalf of my Chief Minister and my office, I once again welcome you all to the holy soil of Lord Jagannath. Now may I request the Learned Solicitor General of India, Sri Tushar Mehta, to deliver his address.
Good evening to all of you, the honorable dignitaries on the dais and dignitaries of the dais. We have already crossed our time limit and you have been attending and hearing everyone with captive attention. Anything further by me at least will only mean that I am treating you as a captive audience also. We have yet to hear good words, wise words and words of wisdom from honorable judges, Dharmendra ji, the honorable law minister, etc. So I will not take much time. The government has taken mediation very seriously, which is reflected from the fact that in 2024, now there is a proposed Commercial Court Amendment Act, which permits even an interim order to be passed. Because the major difficulty which was found in operationalizing the mediation as a concept of dispute resolution mechanism was that in case of emergency there was no provision. Now, subject to the bill being passed with modification, without modification, but there would be a kind of mid-RB regime also, that is a fusion of mediation and arbitration. The government and the government law officers are committed, and we will do our best at our level to ensure that before we come and trouble the honorable judges, there is a mediation, and mediation is not only just an empty formality, but it is successfully implemented and effectively becomes an answer to a very major problem of courts clogging dockets. I am thankful to my dear friend Acharya Sahab. He has done an excellently well thing. He has set a benchmark, and every other conference henceforth will have to meet this benchmark, which itself would be a very difficult task. I am thankful to the organizers, thankful to the government, and thankful to my learned friend Mr. Acharya for giving me this opportunity to be before you, such an august and learned audience. Thank you so much.
Now may I request Honorable Sri Justice Shangam Kumar Sahu, Judge, Odisha High Court, to deliver his address.
Jai Jagannath. Good evening to all. Honorable Justice M.M. Sandresh Ji, Honorable Justice Sanjay Karol, Honorable Justice Ahsanuddin Amanullah, Honorable Judges of the Supreme Court, Sri Dharmendra Pradhan Ji, Honorable Union Minister of Education, proud son of Odisha, Sri Arjun Ram Meghwal Ji, Honorable Minister of State, Minister of Law and Justice, Government of India, my Chief Justice Harish Tandon Ji, my esteemed brother Justice Krishnaram Mahapatra, Justice Sanjeev Kumar Panigrahi on the dais, Mr. Tushar Mehta Ji, Learned Solicitor General of India, Mr. Pitambar Acharya, Learned Advocate General Odisha, Honorable Chief Justices and Honorable Judges of different states, Mr. R. Venkatramani, Learned Attorney General, sir, my sister and brother judges of High Court of Odisha, Mr. Prithviraj Harichandan Ji, Honorable Minister, Law, Works and Excise, members of Registry, Odisha High Court, government officials of the state of Odisha, dignitaries from different parts of India, members of print and electronic media, ladies and gentlemen. आपण माने समस्ते आम मानकर निमंत्रण स्वीकार करी एही द्वितीय राष्ट्रीय मध्यस्थता समावेश रे एते संख्या रे जोग देइथिबारु मो तरफरु एवं ओडिशा हाईकोर्ट तरफरु आपण समस्तंकु धन्यवाद अर्पण करूछि. I thank all of you on my behalf and on behalf of Odisha High Court for accepting our invitation and coming here to join the second National Mediation Conference 2025 and participating in the conference. I know how much efforts have been put by our learned Advocate General under the able guidance of the Honorable Supreme Court judges and active cooperation of the Government of India and state government to arrange this program to make it successful. There were obstacles, but the learned Advocate General was of the firm view, and he was of that belief that the greater the obstacles, the more glory in overcoming you. Thank you, learned Advocate General. Whenever learned Advocate General used to meet me and discuss about this conference, and becoming a little apprehensive, I was telling him, you do your part, leave the rest to Lord Jagannath, and his blessings will be always there, and all the obstacles will go away. And you see the result. All of you know that the Mediation for the Nation campaign, which is a 90 days initiative launched by the NALSA and Supreme Court Mediation and Conciliation Project Committee to settle pending cases through mediation in different courts from 1st July to 30th September 2025, aiming to reduce the judicial burden and provide a people-friendly alternative dispute resolution method. The campaign involved identifying cases, referring them to mediators, and taking all necessary actions to facilitate amicable settlement. During such period, as per guidance and instruction of the Honorable Supreme Court in my High Court and 30 districts of my state, 14,206 cases were referred to mediation by 22/9/2025, and 2,744 cases were disposed of. These cases relate to matrimonial disputes, accident claims, check bounce cases, commercial dispute, service matter cases, consumer disputes, debt recovery cases, partition cases, and criminal compoundable offenses. Odisha State Legal Services Authority organized 5 numbers of 40 hours, which we called 5 days mediation training program in Odisha Judicial Academy, Regional Judicial Academy Ongul, and ADR Center Baleshwar. Chairpersons of permanent Lokadalas, members of permanent Lokadalas, advocate mediators of different districts participated in it. A referral judges training program on mediation was organized by the Odisha State Legal Services Authority through virtual mode for all the judicial officers and referral judges, including the secretaries of District Legal Services Authority of the state of Odisha. The master trainers of MCPC of the Honorable Supreme Court acted as the resource persons. In all the 30 districts, the referral judges training on mediation have been completed. People are now looking for early solution that can put an end to their difference so that they can move forward to seize new opportunity and not be held back due to pending disputes, non-clarity about their claims. It is here that this mediation, by offering simple, quick, and easy solution, becomes relevant. Mediation is built around a culture of give and take, and it creates an opportunity to arrive at a win-win formula. When a dispute is resolved through the mediation process, there is no winner or loser as the parties agree to a solution, whereas in litigation there is always a loser. This is the positive outcome. Mediation avoids hostility and offers an opportunity to restore trust between the parties. Most importantly, as compared to court procedures, considerable time and money is saved in the mediation procedures. There is no dispute that the government is the biggest litigant, and there could be a system by which mediation could be effectively used for settling the dispute where government and its agencies are party. Some innovative thinking on this aspect is necessary. Father of Nation believed in mediation as a powerful tool for resolving dispute, seeing it as application of his core principle of ahimsa, satya, and sarvodaya. Honorable Chief Minister Odisha yesterday laid emphasis on mediation connecting to the broader goal of social justice, especially for the poor and needy who seek to redress grievances through the court. I just give you something that during my justice 12 matrimonial appeal cases in which decrees of divorce were passed by the family courts were settled with much efforts by we the two judges. You can't believe the happiness, the tears of joy which we saw in the eyes of those parties. The family reunion gave immense satisfaction. Today, right from 10 a.m. on different themes, interactive sessions were held and important discussions on various aspects of mediation were made. I'm sure the purpose of organizing this National Mediation Conference has been fulfilled. The conference will be highly beneficial not only to the participant but also for our state and to the entire nation, and we must utilize whatever we have learnt so that access to justice for all, in particularly to the poorer sections, be achieved in its fullest extent. Thank you. Jai Hind, Bande Utkar Janani.
May I now request my Chief Justice, the person who is the principal motivator, philosopher, guide, and has never grumbled for anything which I have suggested during the last 2-month-long preparation for this conclave. I request His Lordship, the Honorable Chief Justice of Odisha High Court, Sri Justice Harish Tandon, to deliver his address.
The distinguished guests on the dais and off the dais, the friends and ladies and gentlemen, though it was a commitment by the Advocate General that because of the paucity of the time, and then we have already crossed the this time slot which was allotted, so I will not be speaking for the occasion. But I do not know. I have been ordained to do this exercise, so I have come before you. We have been going through the different technical sessions throughout the day on a diverse topics, on a diverse the subject or the lapse, the gaps, the challenges which the mediation would face or have faced which we experience while going through the mediation process, whether it is the court annexed mediation or it is the pre-litigation mediations. And the erudite speakers have already highlighted those aspects of the mediations, which is definitely food for thought, and we take home a lot of stuff to introspect, to ponder upon, and how to give an impetus to this particular process of mediations. I have one suggestions, because we all talk about the pre-litigation mediations when the dispute cropped up, and a court annexed mediations when the dispute has already arrived to the court. Why not we can also think of a mediation when the dispute is yet to be cropped up at a nebulous stage, and the parties should be encouraged to go for a mediations. When the dispute has not really has a reason, but likely to arise in future. We also talk about the MEDAR, which is also a concept. The Singapore concept is the ARB-MED. We can make another hybrid of MED, ARB, and MED, that the arbitrators should also be, sensitized to send the parties, even if they have undergone the pre-mediation, litigation mediations, or pre-arbitration mediations. So this is how the capacity buildings, how to improve the mediation, the drive. These are all have been talked about, and I hope that all of you have enjoyed the whole day, the sessions, and hope that this sessions would continue in a third phase. I believe the third national conference, mediation conference, going to be held in the state of Meghalaya, and I wish and congratulate the organizers there that they will definitely keep the same momentum which we have set a tone in this particular program. Thank you. Jai Hind.
Thank you, Your Lordship. Now I request Sri Arjun Ram Meghwal, the Honorable Union Minister of Law and Justice, Government of India, to deliver his address.
सेकेंड नेशनल मीडिएशन कॉन्फ्रेंस 2025 के वैलिडिक्टरी सेशन में आप सब उपस्थित को सबको नमस्कार करते हुए जय जगन्नाथ। वो तो बोल ही सकते हो आप, जय जगन्नाथ। वेरी गुड, थैंक यू। इस अवसर पर उपस्थित हमारे मध्य ऑनरेबल श्री धर्मेंद्र प्रधान जी, यूनियन मिनिस्टर ऑफ एजुकेशन, हमारे ऑनरेबल जस्टिस MM सुंदरेश जी, जज सुप्रीम कोर्ट ऑफ इंडिया, ऑनरेबल जस्टिस संजय करोल जी, जज सुप्रीम कोर्ट ऑफ इंडिया, ऑनरेबल जस्टिस असुद्दीन अमानुल्लाह जी, जज सुप्रीम कोर्ट ऑफ इंडिया। अभी आपके समक्ष बोल के गए जस्टिस हरीश टंडन जी, ऑनरेबल चीफ जस्टिस ऑफ उड़ीसा हाई कोर्ट, हमारे तुषार मेहता साहब, सोलिसिटर जनरल ऑफ इंडिया, हमारे जस्टिस संगम कुमार साहू जी, और हमारे जस्टिस संजीव कुमार पाणिग्रह जी, और एडवोकेट जनरल उड़ीसा श्री पीताम्बर आचार्य जी, हमारे चीफ सेक्रेटरी मनोज आहूजा जी, और हमारे बीच में उपस्थित एडवोकेट अटॉर्नी जनरल ऑफ इंडिया वेंकट रमणी जी, पिंकी आनंद जी, हमारी लॉ सेक्रेटरी भी बैठी है। अभी मुझे ज़्यादा इसमें नहीं बोलना, ये एज है ADR की। ADR का मतलब अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म। इस पे हमारे प्रधानमंत्री जी नरेंद्र मोदी जी ने बहुत जोर दिया है और ये कहा है कि कोर्ट में जो केसेस पेंडिंग है उनका अगर भार कम करना है तो हमें एडीआर को अपनाना ही पड़ेगा। और एडीआर में 3 चीजें आती हैं, आर्बिट्रेशन, मीडिएशन और कंसिलिएशन, और तीनों पे ही जोर है। इसलिए जब वेंकट रमन जी ने फर्स्ट नेशनल मीडिएशन कॉन्फ्रेंस दिल्ली में की थी, तब भी ये तय हो गया था कि इसको सेकंड भी करना है, और अभी मुझे यहाँ प्रसन्नता हुई कि थर्ड भी तय हो गया। कहाँ करना है? शिलोंग में। ताली बजाना तो जोर से बजा दीजिए थोड़ा शिलोंग के लिए। लेकिन उड़ीसा की जो ये सेकंड मीडिएशन कॉन्फ्रेंस 2025 हुई है, मैं और धर्मेंद्र प्रधान साहब, बाकी और भी ऑनरेबल जजेज यहाँ 4 बजे के आसपास आ गए थे वैलेडिक्टरी सेशन के लिए। लेकिन 4 बजे से जो सुन रहे हैं वो सुन रहे हैं कि इतने चीफ जस्टिस ऑफ डिफरेंट हाई कोर्ट के लोग आए, जजेज आए, सुप्रीम कोर्ट के जजेज आए, इतने तो किसी कॉन्फ्रेंस में आए ही नहीं। इसलिए जो आयोजक है उनके लिए बहुत बहुत बधाई और शुभकामनाएं। और चिंतन मनन मंथन भी बहुत जोरदार हुआ है। अभी हमें करना क्या है कि जो हमारे अटॉर्नी जनरल ऑफ इंडिया बैठे हैं, ये जो तय करेंगे कि चिंतन मनन मंथन में यहाँ क्या क्या चीजें हैं जिन पे हमें काम करना है। तो एक तो चीज आप बताएंगे, फिर हमारी लॉ सेक्रेटरी भी बैठी है अंजू राठी राणा, हम आपस में जल्दी मीटिंग कर लेंगे। मैं ज्यादा समय लूं आपका, उसकी बजाय मैं चाहता हूं कि अपन एक डेट तय करें कि इन 2 दिनों में यहां जो भुवनेश्वर में आपने चिंतन मनन मंथन किया और हमें क्या करना है, वो अगर आप तय करेंगे तो मेरा काम आसान हो जाएगा और जल्दी हम निर्णय कर पाएंगे। बाकी चीजें टेक्निकल सेशन में सारी आ गई है, इसलिए मुझे लगता है कि मैं समय ज्यादा नहीं लूं आपको। बाकी आपके समझ में आया हुआ है ना सारा? आ गया कि नहीं आया? अभी कुछ समझाना है क्या? नहीं समझाना है ना? तो क्या करना है? लेकिन आ गया, ये पीछे से कोई बोला आ गया। लेकिन फिर भी आने के बाद भी दुष्यंत कुमार ये कहता है कि कब तक अपन ये कॉन्फ्रेंस और इसमें उलझते रहेंगे, कुछ ना कुछ तो ठोस करना ही पड़ेगा ना। हो गई है पीर बरबसी, पिघलनी चाहिए, और इस हिमालय से कोई गंगा निकलनी चाहिए। आग मेरे सीने में नहीं, तेरे सीने में सही, जहां कहीं हो आग, लेकिन आग लगनी चाहिए। सिर्फ हंगामा खड़ा करना मेरा मकसद नहीं है। मेरी कोशिश है कि मीडिएशन की सूरत बदलनी चाहिए, मीडिएशन की सूरत बदलनी चाहिए। बहुत बहुत आभार, धन्यवाद।
Odisha has a special connection with Bihar, the Patna High Court. Before Odisha High Court was established in 1948 by a latest patent, our lawyers were going to practice in Patna. So most of my earlier seniors, they had their place of practice in Patna. Fortunately, the next speaker amongst us, Honorable Sri Justice Asavuddin Amanullah, hails from Patna, which was our parent High Court. May I request His Lordship, Justice Amanullah, to deliver His Lordship's address.
Very good evening. Thank you, Mr. Pitambar. I could see the confusion with Mr. Meghwal trying to abridge the speech, how to put it together. He was just shuffling his pages. So I think, yes, rightly, there has been some serious deliberation and everything must have gone. But to give a solemn end, I think little bit of formality too is required. I've got just few points to share. It's a takeaway. I know everything has been deliberated, but yes, and sorry, I'm not taking the risk of individually referring to all the dignitaries on the dais and off the dais, because all of you are known to me and I'm not very good at names. So I don't want to have the risk of missing somebody out. So everybody, hearty welcome. I'm really privileged to be amongst the valedictory session of the second national mediation organized at Bhubaneswar, Odisha. On a lighter note, I am happy to be the penultimate speaker, and I can gladly say that I concur with all that my preceding speeches have said, alluded to. I am also looking forward to the valedictory addressed by Justice Sundaresh, and as such my endeavor will be to the point. Help and not fight, assimilation and no destruction, harmony and peace and not dissension. These were prescient words of Swami Vivekananda. Looked at deeper, one can see pointer towards mediated resolution of conflicts. The Indian civilizational ethos has encouraged and embraced dialogue, reconciliation, community-based resolution and consensus building. From the old panchayat system to informal village council and sabha, the idea of resolving disputes consensually rather than by way of coercion has been rooted in the Indian society and psyche. With the advent of the Mediation Act 2023, Parliament has aimed to further reinforce the rooting and principles in the statute. Dialogue and deliberation from the heart and the mediative process, litigation mostly leaves a winning party and a losing party. But mediation possesses the capacity to let all the people to a list walk away with a greater degree of satisfaction. It can also restore ties and bonds, especially when the parties involved are related to each other. It would not be improper to refer to mediation also in the context of the growing case docket. If alternate dispute resolution ADR mechanisms including arbitration, mediation and conciliation succeed, a direct impact would be witnessed on case pendency figures. I may also put it on record that when the judiciary encourages mediated settlement, it is not shying away from performing its core duty, that of adjudicating disputes. The focus of the judges when referring parties to mediation is to bring about a lasting resolution, however, without a building up of acrimony or hostility. Increased adoption of ADR mechanisms would enable the courts to focus on adjudicating disputes which actually require consideration. Indicating illustratively, intra-family disputes, especially those concerning partition or division of assets, etc., are in my view inherently capable of being resolved through mediation. Further, the choice of mediators should be in the first instance left to the parties alone. If and when a court is called upon to make the choice, due regard must be had to the nature of the dispute and the attendant circumstances, and the mediator should be someone well conversant with the subject matter involved. Yeoman service has been rendered in training mediators by the Supreme Court's Mediation and Conciliation Project Committee, and these trained mediators have gone on to train others in the respective high courts. Mediation offers benefits to the litigants. It cuts down delays, reduces expenses, frees them from adherence to rigorous evidentiary procedures, and directly offers them a voice in the resolution process with the assistance of lawyers if so needed. Mediation is voluntary, non-adversarial, flexible, and fully respectful of the party autonomy. The mediator is not an adjudicator, but a facilitator, an intermediary, if you will, in bringing about a meeting of mind and offering a closure such that not only the referred dispute is nipped in the bud, but the door gets shut to future litigations that may have arisen if the dispute was allowed to be festered. Chris Voss has opined, negotiation is not an act of battle, it is a process of discovery. The goal is to uncover as much information as possible. As I can conceive of it, the road ahead lies primarily on 4 C's: culture, credibility, capacity, and courts. When I speak of culture, it means we judges, lawyers must foster a mindset where parties see mediation not as a sign of weakness, but as a symbol of wisdom. Lawyers must see it not as a threat to advocacy, but as an extension of it. Judges must not see it as an abdication of duty, but as an aid to resolution. When I mention capacity, I refer to the pressing need for still more trained mediators, not legal professionals, but also professionals from diverse fields who understand the nature of negotiation, psychology, business, and of course, human behavior. When I talk about credibility, I emphasize the need for the mediative process to exhibit transparency, accountability, accessibility, and affordability. Without these, no good initiative can come to fruition. When I refer to courts, I urge judges to adopt a balanced approach in referring cases, genuine matters, where judges feel or parties urge unanimously that a resolution of settlement is possible, only must then be referred to mediation. If the dispute in the eye of the referring judge is not one capable of mutual resolution, he or she would be well within his rights or her rights to refuse such reference. Further, if the judge is of the opinion that the plea seeking reference to mediation has only been made a dilatory tactic, mediation should not be permitted. That apart, the court should also refer after reference play only a supporting role and monitor only the outcome and not the process thereof. The court must first call upon the parties and then initially they should convince them to go for mediation, as experience has shown that it gives greater chances of the success. Sensitization programs are needed for both judges and lawyers. This training can also extend to law schools and law universities, perhaps at a one-term subject. I hope the Bar Council of India takes the lead in formulating this, which would go a huge way in equipping fresh law graduates with basic mediation and negotiation skills. This would also help them in litigation and dealing with clients. Most of the court-annexed mediation centers are doing very well and have successful settlement rates upward of 50 to 60%. Thus, government and court administrations need to provide relevant budgetary support, and the necessary infrastructure has also trained staff and allied personnel. Mediation is no longer just an adjunct, but a vital cog of the justice dispensation system. It has been tailored to recognize and act for the human element, which sometimes can get lost in the dust and sweat of litigation. Let us also remind ourselves in the legal profession that we too exist to serve the public trust and uphold the public faith. While our indigenous systems has served well, it would do no harm to study and adopt best practices from across the world, including but not limited to from the Singapore International Mediation Center, the United Kingdom Civil Mediation Council, as also Canada's P3 Dispute Resolution Framework. The Union government has brought in reform with an eye to bettering the ease of doing business in India. I think every public sector unit take the lead in adopting a pre-mediation stance, especially for lower value disputes. To begin with, depending on the results, a call can be taken to widen the net in the issue in the times to come. The sessions over the course of the day have been fruitful, and I am left with no doubt that there is food for thought. To ponder over the mediation as a concept is what it entails, and further what steps need to be taken now and in the near future to ensure the system works. While litigation restores rights, mediation can restore and rekindle relationships. On a parting note, one should always remember that even the father of the nation, Mahatma Gandhi, was a strong votary of the mediation process, albeit in a somewhat different manner than what we see currently in operation. I also recall the Mahatma's talisman, in times of need or dilemma, recall the face of the poorest and weakest man whom you have seen and ask yourself if the step you contemplate is going to be of any use to him. I am sanguine that by the time we meet again for the 3rd National Mediation Conference, we will have an occasion to turn back and see where the journey started, from the distance we have covered and the journey that lies ahead. To sum up, Max Lucado had commented, conflict is inevitable, but combat is optional. I convey my thanks to the organizers, especially the Learned Advocate General and the Department of Law, Government of Odisha. Thank you, Jai Hind.
Thank you, my lord. Now, there is a story. My Lord Justice Sanjay Karol, though his lordship was initially given consent, but due to some family preoccupations, his lordship expressed his inability. But I must admire his lordship's magnanimity to give me a call day before, that even though my name has not been printed in the invitation card, but I would like to attend such a distinguished gathering. We are humbled and bow down before his lordship. Now I call Honorable Mr. Justice Sri Sanjay Karol to give his lordship's address.
On the dais, my esteemed colleague Justice Sundaresh, Justice Amanullah, Minister for Education Shri Dharmendra Pradhanji, Minister for Law and Justice Shri Arjun Ram Meghwalji, Chief Justice Orissa High Court, and judges the High Court of Orissa, Learned Solicitor General Shri Tushar Mehtaji, Chief Secretary. In the audience we have the Attorney General, we have the Advocate Generals, we have the Chief Justices, ladies and gentlemen. A very good evening to all of you. I shall be as brief as the Learned Solicitor General was. To begin with, a big round of applause to the Learned Advocate General who has made this conference a great success, and to his office. Advocate General, you take me back to the year 1999. Same sitting, but different place.
Right.
I was sitting there in 1999 in my capacity as the Advocate General of the state of Himachal Pradesh. Same conference we had in Simla. And today in 2025, we are here sitting in this great town, Bhubaneswar. What has changed since then is this which I wish to speak on. We had 25 states, then today we have 28 states. We had a population of 103 crores. Today we have 146 crores. The urban population was 27%, rural population was 73%. Today it is 35% is urban or more, and rural is 65%. Litigation at that point in time, overall pendency was 2 crores. Today, it is more than 5 crores. Our times were such at that time when the assertion of rights were measured. and the understanding of legal entitlements were circumscribed. People did not know much about their rights. In the last one decade, the legal services movement has grown immensely. We have, as judges, stepped out of our courtrooms and reached out to the people. I'm sure 26 years down the line, the litigation is going to increase. There's no doubt about it. Because the marginalized ones, the have-not ones, have now been made aware of their rights, their duties. The avenues are more, and they are becoming all the more vigilant with each passing day. Therefore, how do we deal with this problem of popularly known as docket explosion, or docket inclusion, I would say that. And the only way is, pardon me if I exceed in saying so, is that we have to, from my personal experience I'm saying, step down from the dais, reach out to the people, understand them, understand their language, understand their problem, and find solutions at the grassroots level. And that can be done, in my considered view, is only if, as has been said by the Honorable Minister, that we have to find solutions in a concerted and a meaningful way. The only way we can wipe out the tears of the teeming millions of this country, citizens of this country, is just to see how best way. The only way we can wipe out the tears of the teeming millions of this country, citizens of this country, is just to see how best, rather than penning our judgments, we reach out to them and solve their problems and bring peace, happiness in the society. I must also say this. Brother Amanullah mentioned about Vivekananda. I must share this with the audience that our guest here, the central minister, also has read and likes Vivekananda. He and I both have tangible relationship with Himachal Pradesh, where I come from. Only thing is that Vivekananda, in Uttarakhand, when he went to Kasar Devi, he was told to come and serve the people. Now, when Mr. Pradhan went to Himachal Pradesh, he was also asked to serve the people of this great nation. And he has been, I must say proudly, serving the people of this great nation. Thank you very much, Minister. I would also say this, that we have 15 Chief Justices here. We have about 44 judges who have come from different states, and we have 12 Advocate Generals. Each one of us have to find solutions at the local level rather than waiting for the result of these conferences. I'm sure with the passage of time, we shall go home, ponder, contemplate, and find a way for having the disputes resolution mechanism enforced with greater success, vigor, and emphasis. Thank you very much, all of you, please.
Now may I request one of the senior most cabinet ministers of Modi government, a friend, philosopher and guide to me all through, and more than a family, Sri Dharmendra Pradhan ji, to deliver his address.
Honorable Justice, Supreme Court of India, Mr. M.M. Sundaresh ji, Honorable Justice Sasuddin Amanullah ji, Honorable Justice Sanjay Karol ji, my colleague Sri Arjun Ram Meghwal, Union Minister of Law and Justice, Honorable Chief Justice of Odisha High Court, Justice Harish Tandon ji, Justice Sangam Kumar Sahu ji, Justice Krishna Ram Mahapatra ji, Justice Sanjeev Kumar Panigrahi ji, Solicitor General of India, Advocate General of Odisha, my elder brother Sri Pitambar Acharya ji, Chief Secretary of Odisha, Mr. Manoj Ahuja ji, esteemed dignitaries, respected members of judiciary and legal fraternity, distinguished guests and ladies and gentlemen. Judiciary is more patient than our political ecosystem. If you will address a meeting at this time of the 2 days conference, when I entered the room after waiting 3 hours, again I go back and I again come back, I asked my dear friend Mr. Acharya, anybody is there? He said, you come and see. I am thankful to all of you. You all are here to listen, honorable justices and honorable guests. Friends, I welcome all of you, my state Odisha. For which reason you have chosen Odisha as a place of this mediation second conference, but I am fortunate to tell you few things. This land is itself a land of mediation. You all might have visited Lord Jagannath Puri Mandir. In Puri Mandir there is a concept Patita Pavan. There is a Patita Pavan Vigraha not in the sanctum of the temple, in the just outside of the temple, gate of the temple. There is a story behind that. That is to my learning as a child, as a practice of Odisha civilization, as a devotee of Lord Jagannath. Friends, there is a dispute between system and devotee. One devotee who is a non-Hindu, is a Muslim, his father was a Muslim Sipahi of the Mughal period, of the Puri king, and mother was a Hindu. The boy Salabeg was very devoted to Lord Jagannath. Every day he come to the Singhadwar in front of the gate in the Baradan, and he write many beautiful and devotional songs in the dedication of Lord Jagannath. Looking into that, the king did one the fast mediation, I think, to my understanding. The king facilitated a vigraha just outside the sanctum and put it in the gate and facilitate and create a mediation between Lord, the Supreme Lord, and devotees. You all are here in this holy land. I congratulate all of you. This 2 days deliberation will certainly create new pathway. There are 4 crores pending cases and the different level of courts. I hope this new initiative by judiciary and by government will certainly create new ease for the society. And you all are here in the Lord's place, the mediation's place. And in Odisha, another believe, Bhadraloki. Those who are from the eastern part of country, they know what is the concept of Bhadralok. In our society, Bhadralok's job is to do mediation. Mediation for local dispute, mediation for marriage, mediation for education, mediation for many things, for many disputes. And I welcome you in the land of Bhadralok. Friends, fortunately, coincidentally, I am in charge of education minister of country. Everybody has their own interest. I have my own interest to come here. I am thankful to my dear friend Pitambar Acharya ji. He invited me to this conference. I thought I should go to the Bhubaneswar conference to welcome all the legal illuminaries and dignitaries of the country in my native state. So I am here. But I have another motive in behind to behind to come here. NEP recommends multidisciplinary. NEP, National Education Policy 2020, recommends education through mother tongue. I am thankful to Indian judiciary. You all have consciously decided to adopt Indian language as court language in many states. I congratulate all of you. I pay respect for the great decision. I think, but according to my own understanding, how do we create a zero pendency of this 4 crore case? Corona created a new ecosystem, that online argument. I think using technology. Today is a Sunday, last Sunday of month of September. Prime Minister Narendra Modi, as usual, put his word through Man Ki Baat to the countrymen. Friends, since last 2-3 Man Ki Baat, there is a new things coming up. Using technology, using AI, the Prime Minister is communicating to countrymen in all the regional languages. All these things are recommended in NEP. Mother tongue, technology embedment, these are the recommendations of NEP. Time is not far away where judiciary is already adopted technology in their arguments, in their deliberations. AI kind of tools can be embedded, can be used to deliver fair justice, for the to liquidate to the decline, to decrease the pendency of the cases. I urge to the Indian judiciary through this mediation conference, mother tongue based argument, mother tongue based judicial procedure and using technology, can we give more justice? And this is the real reason, this is the real cause of inspiration of justice. And you all are here to deliver, to discuss and deliberate all this important thing of mediation. And lastly, I can say, I seek your cooperation to suggest, because for me, mediation is part of the thought process. If you are a democrat person, if you are a cultured person, you don't go for dispute. Mediation is part of your day-to-day life. Mediation is the pathway for thriving things, for the bigger achievements. So can we create some modules for new sanskar, how people will not be becoming litigant? People will be democrat, people will be accommodative, people will be, and this mediation is not alternative dispute resolution mechanism. I think for me this is a real dispute resolution mechanism. So this two-day deliberation of Bhubaneswar is a grand success, and I expect from education sector more advice, more cooperation. How can we create a culture of mediation in society through education? Thank you, friends.
Before it concludes, Honorable Minister of Education, Government of India, Sri Dharmendra Pradhan ji, my Lord Honorable Justice Sri M. Sundaresh ji, my Lord Justice Sanjay Karol ji, my Lord Chief Justice Harish Tandon ji, the Union Law Minister Sri Arjun Ram Meghwal ji, Justice S.K. Sahu, Honorable Justice K.R. Mahapatra, Honorable Justice Dr. Sanjeev Panigrahi, the Learned Solicitor General of India, Sri Tushar Mehta ji, the Chief Secretary of Odisha, Sri Manoj Jahuja ji, and in my front, seated on the audience, the main architect and the motivation behind all these conferences, my most respected learned Attorney General, Sri R. Venkat Ramaniji, who in fact started this initiative on 3rd of May 2025 in New Delhi and handed over the baton to me in the said conclave. I do not know how much I have been able to carry out the wishes of the central government, but this much I can candidly confess today, that the entire credit goes to the distinguished participants, those who have come from all corners of the country, and it is their generosity, not my endeavor, to make this conference a grand success. I will not take much time. We are already running behind the schedule. I cannot take individual names, but let me give a special thank to the Honorable Chief Minister of Odisha, Honorable Law Minister of Odisha, the Chief Secretary and his team, the DG of Police and the entire police force of the state, the Chief Administrator of Sri Jagannath Temple Administration, who has taken all the pain to remain personally present in Puri Jagannath Temple for safe darshan of Lord Sri Jagannath, to the Commerce and Transport Department, of course, his spouse, Usha Padhi, who has taken care of the entire transport of the dignitaries, and to all the government officers, those who have given their tireless effort to make this conclave a grand success. I will not take much time. I once again thank the Honorable Chief Justice of my High Court, my Honorable other judges, the Registry of the High Court, the law officers of Advocate General's Office, and the entire success story behind this conclave are 30 young girls, those who have been working with me as research associates in Cuttack office and Delhi office. Till 3 a.m. night, all of you would be surprised, they walk with a smile. When I was confused whom to take and whom not to take in the panel of discussion, I took the help of Honorable Justice Suryakant, and you will be surprised. From 10 p.m. till 1 a.m. morning in the night, 3 hours, we sat together. Mr. Nataraj was there, the Additional Solicitor General of India. We finalized those speaker lists. Many must have been left. My apologies to all of you. And once again, I cannot but offer my gratitude, a sense of gratitude to all of you, those who came here taking all the pain. Thanking you all. Once again, we wish to meet in Meghalaya. The Advocate General of Meghalaya has already given his consent to hold one such conference in Shillong. So see you in Shillong sometime in February or March. Thanking you all. Jai Jagannath. Now, I humbly invite the most humble, I repeat, thy name we should call is sobriety, humility, and greatness. My Lord Justice M.M. Sundaresh, who has all through been a great support and has guided me at every stage to make this conclave a success. My Lord Justice M.M. Sundaresh to deliver his keynote address.
I think I need a clap. I must tell you there are two reasons. As the Advocate General said, mine is a valedictory address, and therefore the day's hard work and agony is going to come to an end. Secondly, I am going to make my speech very short. So this would make the audience happy. Honorable Sri Dharmendra Pradhan, Honorable Minister of Education, Government of India, my respectful brother, Sri Sanjay Karol, Sri Asuddin Amanullah, Honorable Sri Arjun Ram Meghwal, Minister for State, Honorable the Chief Justice of this great High Court, Sri Justice Sri Justice Harish Tandon, Honorable Justice Sangam Kumar Sahu, Honorable Justice Kursharam Mohapatra, Dr. Justice Sanjeev Kumar Panigrahi, learned Attorney General, learned Solicitor General, Chief Justice of various High Court, judges from the High Courts, distinguished invitees, and the last but not the least, my dear students. I can't say it's a good evening or good night. Where do we start the mediation? How did it emanate? I was just pondering in the morning. I believe mediation came into existence before human being. Why is it so? We can look at the world in two different ways. A world full of conflict, a world full of cooperation. A living being for his existence requires the help of others. Let us imagine few chicks in a nest craving for food from their mother. There may be a dominant chick among them, there may be a weak. But the mother makes sure that everyone has his own share. Mediation starts at an earlier date than what could possibly perceive. It's a way of life. It's a natural way of living. We see mediation at home. Fight happens between sister and brother, husband and wife. This great country believed in mediation. Now, it was said by the Honorable Minister about the huge dependency. When this country believed in mediation, it led to an orderly society. When an alien power took over and brought a system which is adversarial and procedural, it completely obliterated and killed mediation.
And that's the reason why we have 5 crores of cases today. With a sense of responsibility, I am telling you, the huge pendency of the cases involving various enactments along with the complicated procedure law has made the great institutions suffer. Therefore, we have to go back to our roots to bring back the old concept of mediation, which is part of our life. Yesterday, in the inaugural session, Honorable Minister for Law and Honorable Chief Minister were talking about mediation during ancient times. A reference was made to Mahabharata and Ramayana. I asked myself, what happened and why did it fail? Lord Krishna was an acclaimed speaker, a respectable speaker. Why did his mediation fail? In my view, mediation never fails. At times, the process might fail. It failed because of the lack of trust. While he was respected, but unfortunately he was not accepted. Duryodhan felt that he was a mere emissary from the other side. Now the failure was also due to the fact that good people surrounding him miserably failed to take part in the mediation. Be it his own brothers, aging father, his uncle, guru, grandfather and friend. Did all of them not fail in their duty to advise him? Was he not told about the effect of the failure? A mass destruction. I apply this to Ramayana also. Lord Hanumanji, some of you might know, is an extremely powerful speaker. He could speak according to the situation and according to the persons. His words would exhibit pearls of wisdom. And that is how he successfully completed an agreement between Lord Rama and Sugriva. However, when he was sent to Ravan, he changed himself. He was seething with anger that Ravan had clandestinely taken Goddess Sita with him. Perhaps the diplomacy we exhibited in clinching the deal earlier was missing. Secondly, as in the case of Duryodhana, all the wise men surrounding Ravan also did not adequately advise him. I only quote these examples to show that trust is the key. Unless the parties believe in the mediator, success would not be forthcoming. We are dealing with individuals. Convincing an individual is the most difficult task. We are dealing with individuals with utmost ego and desire. I am reminded of one little story. Tolstoy, one of the finest writers ever produced, went for a stroll in a park. While he was sitting in the park, a small girl of 5 years came running. So she asked him, "I am alone, would you like to play with me?" Tolstoy looked at the young girl and said, "All right, I will play with you." So they are playing with each other for nearly half an hour. Sun was setting. So the girl told him, "I would like to leave. My parents would be searching for me." So at that point of time, the gate man told the girl, "Tell your parents that you were playing with Tolstoy." He wanted to give a subtle message that the parents would tell the child that he was indeed lucky to have met and spent some time with a great thinker. Pat came the reply. The young kid told him, "When you go back, tell your people you played with Mary. That's me." To break this ego is a role which is required to be played by the mediator. Before I end, I would like to share my views on the new enactment. As the learned Solicitor General has said, it's a work in progress. All that I can tell the learned Advocate Attorney General and the Honorable Minister and the learned Solicitor General is that before you embark upon new amendments, kindly consult all the stakeholders, including the High Court, because they have a distinct role to play. So with these few words, I thank all the organizers, including the Advocate General, for giving this opportunity. Thank you very much.
We are deeply honored, my Lord. Actually, Honorable Minister, Justice Karol and the Learned Solicitor General, they have a flight. They have already shifted twice, thrice rescheduled. They have some important work. It is at 10:30, hardly 45 minutes left. So they have to immediately rush. So therefore, I would request Dr. Justice Panigrahi to give a brief and as precise as he can a vote of thanks.
Good evening. Sri Dharmendra Pradhan ji, Honorable Union Minister for Education, Justice M.M. Sundaresh ji, Judge Supreme Court of India, Justice Sanjay Karol, Judge Supreme Court of India, Justice Asanuddin Amanullah, Judge Supreme Court of India, Justice Sri Arun Ram Meghwal ji, Honorable Minister for Law and Justice, Sri Venkatramani ji, Attorney General for India, Justice Harish Tandon, our Chief Justice, all the Justice, brother and sister justices present here, Sri Prithviraj Harichandan ji, Minister for Law, Government of Odisha, Sri Tushar Mehta ji, Learned Solicitor General of India, Sri Pitambar Acharya, Learned Advocate General of India, and all the Advocate Generals who are present here, who are from, they hail from different states, and the Chief Secretary of Government of Odisha and his team, Srimati Anju Rathi ji, Union Law Secretary, learned panelists and all the delegates, all the official protocol and print and electronic media. I am standing between you and your hunger, so I am trying to be as brief as possible. Therefore, thank you all for being here, and we sincerely apologize if there is any shortcomings on our part in hosting, and hope you will show a great heart. Bande Utkala Janani. Thank you.
Jai Jagannath. Thank you very much, Dr. Panigrahi, Justice Panigrahi, for understanding. And everything is well. If it goes well, the conclave conference stands concluded. Thank you very much.